On MorningLine, thanks for joining us. Our guest, attorney David Raybin. It's always good to have him on. So many topics that he can touch on with the law. We were talking with him this morning. We already touched on the Lindsay Lowe case. We're going to continue talking about the harsh juvenile sentences and the changes and what that means moving forward in truth in sentencing. Another case that's made news real quick, we were talking about this during the break. There's a Vanderbilt student, and the story kind of broke last week, who is being stalked by an individual. He's been arrested, my understanding, in violation of orders of protection 3 times. In fact, at one point he was locked up before he was released on bond and called her from the jail cell and continues to do this. And as my understanding is, he's still free as we speak right now. 3 times he's been out, making a bond each time. And I'm wondering, what's wrong with this picture?
Well, the answer to it is that the state can file a motion to revoke his bond. In other words, when a person makes bond, the judge imposes conditions on the bond, like you can't leave the state, for example, and you can't have a gun, or various conditions that the judge can impose. And one of the conditions is attached to every bond is that you don't violate the law again. Now, we're not talking about him committing a jaywalking and getting his bond revoked, but if he's violated his bond by harassing the same victim, that is, and the state can put proof on that he did that again, then the judge has the discretion just to revoke his bond and lock him up. Because bond is always conditional. You're released on bond, but the bond can have attached conditions, such as financial conditions or behavioral conditions. Like if a person commits a certain crime, they can say you can't drive a car, you can't have a gun, or whatever the judge decides. As long as the conditions are reasonable, and not contacting the same victim again is very reasonable, and you violate that, the judge can say, after a hearing, your bond's revoked, you're going to jail, done. And then the sheriff would put the person in isolation so that they can't call the victim anymore. I mean, that's the way to solve that problem.
I mean, it's been 3 times. I mean, did you see that? I mean, I know you don't know all the details because you're not working that case, but it's been 3 times, and some of them may have been misdemeanors, but I think there's 1 felony out there. You worry that if you don't act on it, at some point he may escalate to harm her. Well, wouldn't that be terrifying for her?
Of course it is, and I've had cases on both sides where a person continues to harass the victim, that sort of thing. As long as there's a hearing and the judge decides, because I had unfortunately cases where people made bond and then the victim said, oh, he's bothering me again, but he didn't, and it's used to harass the defendant. Sometimes it goes both ways, and that's true. But as long as you have a hearing and the state has to put on clear and convincing evidence that the bond conditions were violated, and the person has a lawyer and everything, and there's proof of this, then the judge can just say, you violated the conditions of bond, back to the stony lonesome you go. And that's the way to handle that.
I got you. Okay. I was curious because I'm going to look more into that case as well. It's a head scratcher. All right. Back to the point we were making when we went to the break, looking at the fact that you know, these the way the legislature has gone the opposite direction in some ways. What are the problems? Overcrowding is going to become an issue if you don't allow probation, early release. The main thing is, from my perspective, is I want to make sure if someone's being released that they're no longer a threat, okay? I mean, but I don't want to keep paying for them, just blindly locking them up for all these years if they can get out and not recommit and be safe. Okay,
first of all, unfortunately, there is no system that has ever been designed that can guarantee a person will not commit another offense, okay? Unfortunately, the recidivism rate is like 30 or 40% in Tennessee. It's not only because of the release decisions, is that because when people are in prison, they're not rehabilitated, they're not given the tools, and many times they return to the same situation. I mean, you have a captive audience there. You can do a better job at rehabilitation, and we don't put enough resources into that. But once the person is released, then you can have some pretty strict conditions of probation or parole. But we're paying for that, and that's just part of built into the sentence. We've always had good non-honor time credits. We've always had that. We've always had some release mechanism in Tennessee. Every place in the country does. The legislature says, well, we're not going to have any. We're going to lock everybody up for 100% of their sentence, and that's going to solve the crime problem.
And that's what it is right now. That's what's in place now.
And whatever crimes are left, they're going to do that for the rest of the crimes. Well, as I said, We did that in 1979. I was part of the drafter of one of the statutes. We thought, well, this is going to solve it once and for all. It didn't. It created chaos. The federal court took over our prisons.
And when you say it created chaos, because all of a sudden, without paroling anyone, it got overcrowded.
It got overcrowded. People were stacking up over there, and the work release centers sat idle. You had no rehabilitation. The federal courts finally took over our system. The governor called the legislature back into special session and said, we got to fix this. So many of the paroles and safety valve statutes, which are on the books today, or were, are as a result of that chaos that happened in 1986. So, and then of course the legislature created the Sentencing Commission, on which I served on that. And we had really strict sentences, but it was rational. And then the legislature did away with the Sentencing Commission in 1995 and then created this life without parole for the juveniles and adults. This provision that the Supreme Court just decided will affect approximately 200 people. There are 200 juveniles in Tennessee who are serving functionally life without parole. They won't get new sentencing hearings, but they'll have a parole date. Adults who are facing 51 years, there's over 2,000 people. And so when they changed the law in 1995, had they left the law alone, those people would be coming up for parole today. So they're starting to stack up out there, and with no release.
You have any of them your clients?
Yes. I have several people who are applying for clemency, asking the governor to make an exception for them and to grant them clemency. I had the parole board recommend clemency for one of those people, and the governor's considering that. So,
and can they also apply under the Supreme Court decision now?
No, because they're not juveniles.
Oh, okay. Do you have some juvie clients?
I do have juvenile right now, whose case is in the Supreme Court of Tennessee, right behind this fellow. And so he fortunately will get some relief if I don't get a new trial. That case, I'm asking for a new trial because of ineffective assistance of counsel. But he will get the benefits of this decision on his life sentence.
Which would mean he'd have the possibility for parole after
25 years. I mean, he shot a guy during a drug deal. I mean, he doesn't need to be serving life with no parole. But his lawyer was defective in my view.
Okay, and that's a separate issue on that front.
We're working on.
So I'm just wondering, and this can be complex. You do a great job of explaining it, but for the viewers out there hearing what you're saying, the way it's set up, and a lot of them are going to say, yeah, we're tough on crime, to heck with them, they commit these crimes 100%. I'm tired of hearing that someone's going to do 50 years and they're out in 30, you know? How do you explain to them, why it's not a bad thing to let some of these individuals out on the judgment of a parole board after they review them and recognize that maybe they can go out and not reoffend?
You want to have discretion at some point. The police officer has discretion whether to arrest or not. The district attorney has discretion whether to prosecute. The juries have discretion. Judges should have discretion. To me, it makes no sense to have a wooden system where discretion is removed. I mean, these judges are brilliant people. They have a long experience, either as prosecutor, defense attorneys, have been to law school, and they have all these tools in front of them. Let them make their decision. And if they make the wrong decision, the other side can appeal, so that we have safeguards, we have checks and balances. People believe that if you commit a serious crime, like we had the offense where two 15-year-olds shot the market owner a couple of weeks ago.
Yeah, it's awful.
From Kentucky. Yep. Horrible, horrible, horrible crime. Those two fellas are going to be tried as adults. Let me kind of step back one and talk about the juvenile system, where that came from. Around 1900, if you were 9 or 10 years old and you committed a felony, you went to the penitentiary. Right out here in West Nashville. So they had people as young as 9 or 10 in the state prison.
With adults?
With adults.
Yeah.
They maybe had a separate wing for them, but you put a 9 or a 10-year-old in the state penitentiary out there. It was like this all over the country. And punishments, they would whip people with belts and that sort of thing, or hang them up by their thumbs. I mean, it's pretty barbaric. So in Tennessee, as every other thing, we created a juvenile court system. And we said that juveniles are different.
That was about what year?
The juvenile court system came in about 1900, something like that is when they started changing little by little. And then it became more formalized. And we had juvenile courts through the years, and probation was allowed. But we came to the idea, which is what the Supreme Court said, is people who are juveniles are less mature. Their brains don't work the same. We think about ourselves when we were young. Some people argue that you don't really mature until you're about 25. And some of us, Nick, are still working on maturity. But basically, the courts say that universally, a young person does not have the same decision-making capability. They may commit a horrendous crime and should be held accountable. But because of their youth, because of their immaturity, we're going to consider that in the sentencing decision. So we created a juvenile court system. And some people argue that it went too far the other way, because the judge can really hold somebody till they're 18 or 19 and then let them go. So they created a system of trying juveniles as adults. And I suggest that may have gone too far the other way, that you say a person who's 14, 15 years old commits a murder, the juvenile judge can say, look, this is too serious. I don't have enough punishment that I can impose on you. I'm not going to let you out when you're 18 or 19. You go into criminal court. But then you're facing the full panoply of punishments that an adult would face, which is life without parole. So maybe people are talking about what's known as blended sentences, whereby a juvenile court judge can say, look, after a jury trial, maybe I can impose a sentence and let you out potentially after 25, or maybe even 30. So it's a blended sentence. So you don't have quite the harsh attributes of an adult sentence, but you don't have some of this really, really, really low sentences, which do nothing but push people into adult criminal court.
Okay, and we'll take a break on that, but just when we come back, then I want you to answer. There's some that I know will be watching that say, okay, David, if an adult committed that same murder that juvie did, they might be looking at life in prison. Why should that juvie be given a blended sentence when he still or she still murdered someone the same way? And I'll let you answer that when we come back right after this. We've got some phone calls too.